Welcome to the DYK podcast. In today's episode, we have a fascinating guest who teaches at Texas Christian University. His name is Daxton Chip Stewart. And Professor Stewart, first, welcome to the podcast. And I'm going to talk a little bit about your amazing resume.
Terrific. Thanks for having me on.
Yeah, really looking forward to this discussion. So you've done a lot of things in your career. You have a broad array of credentials. You have a doctorate from the University of Missouri. You have a law degree from the University of Texas School of Law, an LLM, which is another law credential from the University of Missouri School of Law. You also worked as a sports journalist for a while and also were a sports information director in an athletics department. And now you teach on the intersection of law, journalism, and sports, and with an emphasis on transparency and public records requests. And that's really what we want to talk about, the transparency issues. And you teach 4 courses. I'm assuming you teach undergraduates?
Yeah, largely undergraduates.
And so you teach Introduction to Journalism, another course on sports journalism, another course on law and ethics of mass communication, and then a course on contemporary issues in sports media. And I'd like you to talk a little bit about your coursework, and then I'm going to segue into some of the interesting assignments that you've given your students that really, I think, highlight some of these transparency issues.
Sure, absolutely. Yeah, I was, started my career as a sports writer before becoming a lawyer, and I've always enjoyed seeing the connections between those sorts of things. Over the last 10, 15 years, I've really gotten into digital technology, social media, and studying that as well. And part of my journalism background, it has been in open records, open meetings, and transparency, this kind of government accountability. And if you've worked at universities before, particularly public universities, you know that's a government entity, and and a bureaucracy built in, and could do for a good bit of transparency. And so there's a good opportunity for journalists, but also for students to study this, to kind of practice their journalism skills working at universities. So one of the assignments I do is actually in my law and ethics of mass communication course, is I require my students to do an open records request every semester. It's just kind of a real practical, using the law. This is something journalists do, and something I have certainly done plenty of over the years. And while often we will do our request on, a public interest sort of thing, back before it was a modern phenomenon coming back again, we asked about books being removed from school libraries, for example, 5-6 years ago. We asked about vaccination, again, before it became a thing, vaccination rates for your regular, kind of routine vaccines at public schools here in the Fort Worth area. So we would ask about those sorts of things and ask for records to try to do an investigative project. We partnered with the 4-Star Telegram on one of those, for example. But this last year, I decided to do something a little more fun and a little more sports entailed, or sports tied. We decided to ask for the beer sales at home football games at state universities, at several state universities. We asked for about 45 of them last fall.
And those were mostly Power 5 schools. I think you had some non-Power 5 schools in Texas, but they were almost,
what we tried to do is we really wanted to hit the Big 12 and SEC. That's where a lot of our students are from, and some from the California area. Again, a lot of our students are from there as well. So we started to hit some Pac-10 as well, or Pac-12, whatever we're calling it these days. And I also wanted to I found out where students were from. They told me what states they were from, because sometimes some states require you to be an in-state resident to make requests. Right. So we wound up with some ACC as well. And then some, because they were Texas and they were regional, sometimes when some of their first choices fell through, we'd go to some Texas universities as well.
Yeah, I want to get to some of the details of those requests. Yeah, sure. But when you're framing the context for your students on transparency and public records, at the values level, how do you talk about that? And what are the values that underpin government transparency and public records requests?
Oh, sure. Yeah, it's something I teach early in the course, and it's just as a central core tenet of living in a democracy, is that the government should be accountable to the people, and that we as citizens are the rightful owners of these records. They are not the government's records. They're our records because we pay for them. Like, our tax dollars pay for the bureaucracy. We pay for the people in the bureaucracy. We pay for the people generating the documents. So these are our records, and we need them to know what our government's up to, how they're spending our money. Are they doing things well? And This is our main access to accountability, that if we know what the government's up to, they're not doing things we like, then we can vote them out, right? Again, a central tenet of democracy is accountability and transparency.
Right. And do you tie those to constitutional principles, the First Amendment principles, free speech?
It's interesting. I teach, and some of it's because when we do an open records project, we need so much time to do it. I teach open records before I even get to the Constitution.
Okay, right. It's complicated for undergraduates.
So I did. And so actually in my course right now, we're just getting into the First Amendment, free speech,
Okay.
and kind of constitutional history and philosophy and theory underpinning free speech and why we protect it in a democracy. But yeah, I mean, those are all intersected. Of course, the right to know, as we recognize that this transparency right is not in the Constitution. There have been efforts to make it explicitly a First Amendment right that have failed over the years. And so what we have instead is a patchwork of state laws and, of course, the Federal Freedom of Information Act, where states have guaranteed these rights to citizens. And some have actually put them in their constitutions, like Florida, for example. But these are, while they're not necessarily constitutional principles, they certainly kind of fit into democratic theory and why we have a constitution and representative government the way we do.
Yeah, that's so important, that connection between,
Absolutely.
our constitutional freedoms and transparency in government. You do this semester to semester, year to year. What do you think most students kind of assume coming in about government transparency and whether they tie that to these really important American values?
It's interesting. I don't know how much they come in, what kind of expectations they come in with transparency. Probably not something they talk a whole lot about in advance of my course. Hopefully they do somewhere in a civics course or something like that. Most of them have not filed an open records request before coming to my class. Some of them are student journalists, so they may have done it for a previous class or in while working for the student newspaper or broadcast or whatever that is. But it's once we start talking about it, they seem to get pretty excited about it. It's one of those things that during the semester, I usually get pretty good feedback from students. They really get into the negotiating, finding things out. They get excited when they get good responses. They come to class and brag about them. It's great. And then years later, when I get notes from students that come and visit, they'll say things like, the open records assignment was the most important thing I did in college.
Yeah,
right? And that's what I use in my job more than anything else.
Yeah, that case method approach is so valuable as an educational tool.
Yeah.
Let's talk a little bit about the assignment you gave to your students last semester on beer revenues at these schools. And if you could just sort of give us an overview of the number of schools and then the responses that you got. And I think that'll be a good segue into some of the barriers that public institutions put up to providing these documents. And this was I viewed it as a pretty innocuous request.
Right.
This isn't something that's going to be headline news. Although I think that the failure of some of these institutions to respond should be headline news.
Yeah, right. Yeah, and that's when I'm coming up with these assignments and talking with the students, I try to make it something that's relatively accessible. It's something that they care about, they actually want to get answers to, and also something that, again, is not really very controversial, that I can't imagine somebody wanting to litigate or deny and drag these things out for months and months and years, the same way that if you're trying to get emails between high-level administrators on a controversial issue, that's going to be a lot more contentious. You're a lot more like, this is pretty harmless. Like why would you want to keep beer sales secret, right? There's literally I can't think of a motivation why. Nevertheless, so we asked about 45 schools. I forget the exact numbers off the top of my head, but we wound up with about 25 responses to those records requests. Okay. This is about over a 10 to 12 week period they made the request. But of course, this was last fall. Some of these requests are still ongoing. We actually had one in the last few weeks come in well after the last semester ended. That was Cal, just for what it's worth. And some have still not gotten responses. Some of the students have just kind of moved on or graduated, so we're not going to get responses. And some we're still waiting. But yeah, so we got about 25 responses. Some were very quick. They responded within days with full records. We generally asked for home beer sales per game in 2022 and 2021. Sometimes, and this is, again, some students only ask for 2022, some only ask for 2021, some sent them to the wrong place. I mean, it's a learning experience, and we're going to have a little bit of inconsistency like that. What I try to do is I built a database of the results, and some sent us really detailed game by game, every bit of alcohol they sold, including beer, and we had to figure it out. Sometimes it's just like a line item that said, here's how much beer we sold. So we got one data point. But most would give us a game by game, just like, here's how much our net sales in beer. And that's what we asked for, was net sales in beer. So they may have sold less beer but charged more for it, or whatever the case might be. But we did not ask for actual beer sold. I know some of this because I run one of the TCU concession stands as a local high school band parent. We volunteer at concession stands, and we have to do inventory on, and there are so many beers, it's hard to keep track and count. So just the beer sales is plenty. We didn't count bottle by bottle on these.
Yeah, I think a lot of people would be surprised at how many Power Five universities do sell beer. There's some that don't.
Yeah.
And there's kind of been a normalization of that over time. But
You're right. That's changed a lot over the last, I'd say, 5, 6 years, right?
yeah, and so who was your most transparent university?
Let's see. I was very pleased with Texas A&M. They came in very quickly. Sometimes they can be a little resistant to requests, or I'm sorry, not Texas A&M, but universities, big universities can be. I think within a week they gave us full data.
Yeah, and you mentioned you did an article on this that was, I thought, really well done, and you had some fun with it. But you mentioned that the University of Tennessee was transparent, and they came out with their records, and they sell a lot of beer.
They were our top finisher. I'd say again, we ranked them by how much beer do they sell per game,
right?
And that was, the numbers may have been a little skewed because it was before the end of the season and it included the Alabama game, which was the number one beer seller of the last 2 years, the Tennessee-Bama game. I went to high school in Knoxville, Tennessee. I got a soft spot for the Vols, so I was very pleased to see this happen.
Yeah, they came in at an average of $500,000 a game.
A game, yeah.
That's a lot of money. That's a lot of beer.
And when it comes to transparency, too, it's interesting because Tennessee has a reputation for being difficult. Because if you're not an in-state resident, they'll just blanket deny your requests. I had a student from Nashville. So I assigned her the request. She made the request, got the data pretty quickly. So that was one where I was anticipating, and when we've made requests in Tennessee before, we've run into issues. But I had a student from there. She qualified as an in-state resident, and we got them pretty quickly. So they were very good.
Right. And, the other thing, I think a lot of people, when they think about public records, they think about FOIA, the federal law, but every state has its own public records laws. And while there are similarities, there are some important distinctions. And as you noted, some states want to honor a public records request from a non-resident. And then also some have, specific timeframes for response. Some don't have any at all. I'm in North Carolina. I don't think North Carolina has a time frame, which gives them a little more flexibility. Let's talk a little bit about the schools that didn't want to provide the information and they resisted the public records request and some of the justifications that the students got for why they weren't going to provide the request. And of course, some schools just simply ignored the request. And that's one of the tactics. Can you talk a little bit about some of the challenges that people seeking public documents encounter typically?
Yeah. Well, let's start with just ignoring your request. And that's delay and deny or ignore you is a common tactic on the public record side. And some of this is because offices are overwhelmed, they're understaffed, or they may just not have a great grasp on the law. Some of it's a bit more nefarious than that. It's just a tactic. You ignore people and hope they go away. Some states do require that you give a response or provide the records within a certain amount of time. For example, Texas says you need to either provide the records or say why you're not providing the records or appeal to the Attorney General within 10 business days of their request. This did not stop the University of Texas from ignoring us entirely, right? And it's like, what are you going to do? We could sue them. And so I guess they're just waiting for us to do that. So that's one tactic we deal with, even when states that do have a time limit, they need to respond. There's not a whole lot of consequence if they don't follow the time limit. So that's one thing, just kind of ignoring. We had a lot of people just ignore requests. One of the things I try to teach here is you've got to be persistent. You've got to keep asking. And eventually they may just give you records to make you go away. Right? That if you just show that I'm not leaving, sometimes they'll give you even more records than you asked for just to make you go away. That's just being a dogged journalist. So there's that part. There's the ignoring stuff. And then you have just kind of the out and out denials and being difficult. I think Alabama was a very good example of that, or a poor example, if you want to. Again, I think karma got them that both Tennessee finished first and beat them in football this year. And I think I like to think that the FOIA gods maybe played a role in that, making sure that field goal went through the uprights. So we had a student made a request. This was not a student from Alabama, and they blanket denied her and said, well, you're not a student, you're not an Alabama resident, so we don't have to respond to you. So I said, well, that's fortunate because I actually have a friend who's an attorney in Alabama and teaches journalism there and is game for these sorts of shenanigans. So I said, all right, his name's Will Nevin. He's a professor at Alabama A&M. I said, all right, Will, will you make a request for us? He said, sure, I will absolutely do that for you. He made the request and they denied him as well, even as an Alabama resident and lawyer, saying that they had no responsive records, which means, if you think about it, that either the request was going to a place that did not have that type of record, but they weren't going to tell us who did have that type of record.
Right.
Or more likely, well, it's unlikely to believe this, but that they don't keep any records about their beer sales, which again, the whole notion is absurd. If you've ever done any accounting, and again, concession stands, of course they keep track of what they sell, because that's, how many hot dogs do we need to make before a game, things I've seen before. I see what those sheets look like in the concession stands. This was the first year Alabama had done beer sales. I believe they had not done it for a few years, and they may still have been pulling things together. I don't want to make too many excuses for them, but that's my guess is that they just didn't have their act together and we're not going to respond to it. And so they're making it as difficult as possible, just begging us to sue them.
Yeah, it's in your article, you have the schools categorized, and the ones that were less than forthcoming, you categorized as skunky beer schools. And I love that.
Yep.
And Alabama was
all of us, they get on the bad list.
Yeah, and Alabama was at the top of the list. And what I thought was really interesting, you had a student who was making a request of Oregon, University of Oregon, and you included the student's comments and the frustration that he or she experienced. I'm just wondering, like on the backside of that assignment, do you talk to your students about how they feel about government transparency and whether their opinions have shifted from what they brought into the class?
Yeah, it's funny. I don't ask that explicitly, but they generally provide it. They volunteer that information. I have them do a final reflection, and it usually is, tell me what happened. If you had success, great. Show me the records and tell me what you thought the process was like. And some of them, again, they're excited. They're enthused by the process. Some are, as you can see, I think from that one comment, they're pretty frustrated that they showed me the work that I made. I called 13 different people, that I called every week. I sent the emails and they bounced me from one person to another. And then they said, when I finally got a hold of somebody, they were all off at a conference, which, you're not supposed to. There's always supposed to be a records custodian there to answer these things. And, oh, sorry, everybody's gone. You have to wait a couple more weeks. And we still have not gotten a response from that university. So it's just that there's ways to make this easy. You can have an open records portal. You can guide people to it pretty clearly through search so they know where to go, and not hide it behind multiple links and then have people not respond to it unless you press them, and then they're all gone at a conference. These are sadly tactics that I have seen cities, counties, universities use I've been probably doing some form of this for 20-something years now, since I was a grad student and journalist at the University of Missouri, at the Columbia Missourian. And it's sadly standard that there's just this type of behavior.
Yeah. So what came through in that list of the schools that were less responsive, I'm trying to put it politely, was that there seemed to be a conscious effort to make it as difficult as possible. And it's like a cat and mouse game. And I want to get your thoughts on why schools on this innocuous request would be so reluctant to provide the information. What are they worried about? And how does that build into the culture and climate of transparency on an institution to institution basis?
Yeah, I think, and there's actually some studies out there, and I've talked to some people on the records custodian side, the records officials, public information spokes officers, for example, spokespeople. And, sometimes they do get a bunch of requests. They're worried about letting stuff out that they're not supposed to let out, because they do maintain a bunch of student private records, and there's HIPAA and there's FERPA, and there's other federal laws they're concerned about. So I mean, there are some legit concerns they're going to have about releasing some documents and some things that might be overly sensitive, communications with lawyers and that sort of stuff. So I get concerns about that sort of thing, but we're not asking for any of that sort of thing. We're not asking for who is selling the beer or give us names, or we're not digging into controversy. We're looking for a line item in a budget. But nevertheless, I feel like that there's that culture in government, and particularly in universities, of secrecy, that when people are asking for stuff, they're up to something and they're trying to get us. And so I think the perspective is they feel like they need to be cautious because they don't want to let things out that's going to get them or their bosses in trouble. So I feel like that's the culture of noncompliance.
Now, do you think that is fueled by the way that athletics departments think about their information and trying to keep everything kind of in-house? Do you see a distinction between the athletics side and then the university side in terms of that climate and culture of resisting?
I say they're distinct but similar, right? I feel like that they kind of emerged, the athletics secrecy culture and the university athletic secrecy culture kind of came from different kinds of places but wound up exactly the same. And where I see that is in foundation work, for example, these private nonprofits that do fundraising for universities and sometimes fundraising for athletics. And these, particularly in the Florida schools, so Florida State, have emerged as a way to dodge public scrutiny. As I mentioned, Florida has very strong open records laws. And so Florida State, for example, says, well, what we're going to do is have our athletic boosters create a nonprofit foundation. All the money goes to them. They're going to supplement the coaches and all these other things, and they're going to build the locker rooms and whatnot. And those are private organizations, so they're not subject to FOIA or to open records laws or state open records laws. And as long as they're operated separately from the university and the university did not create them and does not actually actively operate them, then they can operate as a private nonprofit. And all you're going to be able to get from them is like a 990 form, the nonprofit form they have to file with the government.
Right.
But they're not subject to FOIA or open records laws, or generally not. Some states make them, but Florida's not.
Yeah, and that gets into a whole nother issue. And this is really important. I want to talk about this in the context of some quotes you gave to the Washington Post in 2021, I believe, when they were looking at the fall football decisions in the Big Ten. You have this possession issue, and you have this question, universities will say, we don't own those documents. They're housed in a private entity.
Yes.
And so it's important to understand this private-public separation in terms of transparency. And then also, you sent me a really great article you did in the Journal of Law, Technology, and Internet from 2019, where you talked about efforts to try to create some kind of a nexus between the public entity and then the private entity. And if you could prove up that, that they're sharing money or that they have overlap in some way, you might be able to take the position that private entity doesn't give them cover. And then that also dovetails into the question of, is it where the document sits, or is it the character of the document that governs whether it is publicly available?
Yeah. I'll kind of start with that last point first, that it really should depend on the character of the document or the character of the organization that's creating the document. And what you're talking about there is there's this doctrine in open records laws, federal FOIA, that we call about quasi-governmental agencies. And these are generally agencies or organizations that are on contract with government to do government services. So they might be private, they might be private nonprofits, and these have really emerged, I'd say, last 30, 40 years when we talk about kind of government shifting more things to the private sector, more of its duties, and privately contracting things out. And they're not all athletics. We think about things like school buses. Charter schools may fall in here, right? That they're run by a private nonprofit, but they're on contract with the local school district to provide school services. And so when they're spending government money and they're created by or operated by government, the quasi-governmental document or doctrine suggests or argues that those should be treated like government agencies and should be subject to open records laws. Where it kind of depends is how much control, what does that control look like? What is the kind of the nature of the founding and the operation of that organization? And these have shifted. We've had some debate here in Texas, for example, where another good example is like a chamber of commerce, these kind of these business districts that get created. And a government agency like a city council will say, we want to attract more business, or we want to attract more companies to move their headquarters here. So we're going to provide seed funding and operations and oversight for a travel group or a local business district. And they're going to be our boots on the ground to go and recruit businesses to come here. There's one in Houston. I think it was the Greater Houston Partnership, they called it. It was created by the city of Houston to recruit businesses to Houston. And it was doing just that. And somebody sued for documents because they were retaining a lot of documents and communications with the city. And they said, well, we're private. We're a private nonprofit. Right. And the argument was, well, you're quasi-governmental, that you were created by government to do government things and you receive government money to do it. And despite clear language in the state open records laws, what we call the Public Information Act here in Texas, despite clear language suggesting and court history and judgments in the past saying this is a public agency and they need to give up their records, the Texas Supreme Court said, no, they're private.
Right.
And you can't overcome the Texas Supreme Court. You're not going to file a challenge on the Texas Public Information Act to the U.S. Supreme Court. It's not a federal matter. So, they just basically rewrote the law, and they recategorized these public-private agencies that had long been public agencies. They categorized them as private just by the whim of 5 justices on the state Supreme Court.
Yeah.
Even some of the more conservative voices on it, who are textualists, who read the law, they're like, you guys are just making up law here. This doesn't make any sense. They're all Republicans. I mean, that's the way Texas is, but you have different kinds of Republicans, and you're more kind of legal textualists looked at it and said, you guys are just dead wrong. And I agree with them, but they didn't have the majority. And that's what matters.
Yeah, I want to put a pin in that, the judicial tendencies, how state courts look at these issues and sometimes can be pretty protective of,
yes, they can.
of the government. So, of course, they're a government entity as well. right?
Yeah, right, yeah.
They're
And
kind
of
of,
course, they're not subject to open records
and
laws.
not subject to
Right?
open records request, right? So I
Yeah.
want to use the case study. I want to talk about this Big Ten issue. And in 2020, during the fall football discussions, you had the SEC, ACC, Big 12 saying, we're going forward. You
Right.
had
Yeah.
the Big Ten and the Pac 12 saying, well, we're going to hold off. Those decisions, particularly with the Big Ten and the Pac 12 to not jump in, were very controversial. They were issues of extraordinary public importance and debate and concern. And the Washington Post wanted to get some information on how those decisions were made at the Big Ten. And so they served public records requests. And the Big Ten at that time, before they brought in USC, there were 14 schools, only one private school, Northwestern. So 13 of the 14 schools were large state public universities. And the response that the institutions gave to the Washington Post is, well, we don't have those records, because they had taken those discussions from the public entities, from the universities, put them into the Big Ten Conference communications portal. And the Big Ten Conference, like all these conference entities, are set up as private education nonprofits, which wouldn't on their face be subject to public records requests.
Right.
And the Post they weren't happy with that. They didn't wind up filing a lawsuit, but they reached out to experts in the field. They reached out to you. And could you tell us a little bit about how you saw that issue? And then we're going to talk a little bit more about this tactic of universities taking these sports related discussions, which are so controversial, and keeping them out of the public eye.
Yeah, it's a particular challenge when you're dealing with big state universities, which are clearly subject to open records laws. And then the organizations that bind them together, so like the Big Ten, which is a private nonprofit. Now, in our case, down here in Texas, is the Big 12, right? Or the SEC, or wherever you are now. It's a private nonprofit. Generally, the NCAA, for example, also private nonprofit. These are not subject to open records laws. There have been efforts, again, to designate them as quasi-governmental, and those have failed over the years. That these are generally, while they may receive some state dollars from state institutions, they're not operated by state entities. So, and just kind of take that as a given. Those are private. You're not going to get Big Ten records, things kept by the Big Ten from open records requests. But you can get them from university presidents, right? You can get them from universities. And what happened in this case was the university presidents were chatting with one another, as they do, and sending emails and sending text messages to one another as they were debating and trying to figure out how to move forward on coming up with a football schedule, kind of keeping up with the other conferences. And that's what the Washington Post was able to find at least some of. What they said was they found some of these conversations, some of them extremely frustrating, because I remember one of the university presidents said something like, it's like, well, as long as we just delete all these emails and not public records later. Some of them were suggesting we need to go have this conversation somewhere else so we're not generating public records. And that's ultimately what happened here, was they realizing that when they were, at least some of them knew, or they were aware that they were generating public records by having a discussion via email or via text message, that they went to a private discussion portal. I think it was the Big Ten had created, they hired a third-party company. Think of it as Zoom or a Google Team, or something like that. I don't know I forget exactly what the product was.
Yeah, it was a NASDAQ product, actually.
Yeah.
So the communications software that the Big Ten purchased for its communications, which also I think is kind of a declaration of interest in terms of secrecy.
Yes, right.
And how the lack of transparency there. And you talked about the Big Ten, it's being accepted as a private entity, but when you look at the Form 990s, for example, of all the major conferences, the Power Five conferences, the officers and directors of those conference entities are the university presidents and chancellors in their capacity as university presidents and chancellors. And, on this possession issue, it goes back to this question of, well, is it the nature of the document, and are they doing public business?
Yeah.
Or is it where the document sits, or where the communication occurs? I'm going to ask you to put your lawyer hat on. If the Washington Post had sued the universities and the Big Ten, how would you look at those issues?
Let's see. Where is the Big Ten housed? Like, where are their offices?
I want to say Chicago. I'm not 100% sure.
Illinois. Illinois has a little bit stronger state open record laws, because that's what you'd be dealing with. You'd be filing under the state where it's located and using their open records laws. If the place itself is where you're requesting and they're keeping the documents there. I'm just not that well versed in Illinois law.
Okay. Yeah, but
Unfortunately,
that
but
state
you
law would
basically
go.
would be arguing that they're a quasi-governmental operation, and because their officers and members are university presidents and they're receiving university funding, then that's probably that would be the avenue to go at. Unfortunately, courts, I'd say the last 20, 30 years have been minimizing the quasi-governmental agency doctrine. It's been a hard fight to win. And a lot of this is governments, including universities, been very successful at carving off these private entities and sending them off to kind of saying they're a nonprofit, right? And being able to keep things private there. And a lot of this really dates back to NCAA stuff. The NCAA is kind of they're the white whale. And when efforts to penetrate their secrecy, get into access NCAA documents, a lot of this was during SMU death penalty investigation scandals in the 1980s. Efforts to get NCAA documents failed. That was under, I'm trying to remember, I think that was under federal FOIA, was an effort to get some of those records. And ultimately the federal court said that's not a government agency. That it may receive some government funding from some different areas, but it's not a quasi-governmental agency and it's not subject to FOIA.
That raises an interesting point. And I think I've talked a little bit with you before about this case in Louisville. The Louisville Courier-Journal wound up suing the University of Louisville to try to get public records on the infractions and enforcement case against Louisville arising from the basketball scandal. And their initial responses were, first of all, those documents don't exist or they aren't in our possession.
That's right.
And all of the infractions and enforcement materials are housed at the NCAA and are accessible to member institutions in this really secret view-only portal. So you can't print from it. And you can't access directly the documents. So Louisville's saying that's the NCAA. And of course, the NCAA, like the Power Five conferences, is a private education nonprofit. And so they have argued that they're not responsible for responding to public records requests. But you have this culture of secrecy and you have these devices put into place. And I think a lot of people don't know how the NCAA operates in that regard. And they don't want anybody knowing how they conduct business behind the scenes.
Yeah. And that's the way to get at those kinds of records, is that if the NCAA is communicating with a state university president, you're not going to get them from the NCAA, but you should be able to get them from the state university president. Right. And the trick is, one way they can try to get around this, they say, we will read you the documents and not give you a copy. So it's not in your possession. You don't have a record, right? Or we will show them to you, but then you have to give them back to us. We're only keeping one copy and they're in the NCAA's possession. So yeah, they know what they can do to try to keep these from getting out public. I think that's maybe what happened at Baylor as well. Of course, Baylor's a private institution, was that there were not private institution being regulated, NCAA sanctions by a private institution. The only things that got public were the things that either they wanted public through the third party they hired to do it, or stuff that got leaked. There was no paper trail that's going to be made open to public records. But in the Louisville case, that the way to get at that would be, what documents, if the NCAA isn't giving them up, what documents does the president have or does the athletic director have that the NCAA did give them? Because even if they're in their possession and they relate to government business, they clearly do, then you should be able to get those. And you're right, that's what a way a court's going to say is like, this is somebody doing work related to government work. If the University of Louisville has it, it's a record.
Yeah, and they, of course, raised all the other kind of non-disclosure boogeymen like FERPA, the Federal Student Records Law, because the basketball scandal case is related to the recruitment of star athletes. Yep. And so Louisville said, well, you want information about a student that's protected by federal law. We can't give it to you.
Right. And it's not an academic record. And FERPA is very clearly limited to academic records, right?
Yes. And so they take a very expansive view of FERPA. And that's, as I understand it, and I think you have done some work in this area on name, image, and likeness. Yeah. A lot of schools have said, no, you can't have these records, and they waved the FERPA flag. And as I understand it, so far, that's been a pretty successful defense. If you have some familiarity with that, could you talk a little bit about that?
Sure. Yeah, actually, just as some of this stuff was coming up, I had a former student of mine who's currently a reporter, has been a long-time reporter at a university, or covering a state university, Texas A&M specifically. And then I had a couple of my own students who that semester said, I'm interested in looking at and getting whatever documents universities have about NIL. And so this was probably 2020 or 2021. And so between them, they asked Texas, Oklahoma, and Texas A&M. And what they were looking for was any documents the university had regarding NIL deals that athletes had made. The thought here is that if you've worked in the athletic department and stuff, as I mentioned, I'd worked in SID before, and I've worked with compliance officers. They're going to keep documents on all this stuff. They're not going to want athletes going out and making deals willy-nilly without no oversight from the university, because of course the university is going to be on the hook if the NCAA comes calling. And so they want to know what people are up to. So surely a document exists, or a spreadsheet exists, or there's some sort of form. A lot of open records work is what forms are generated, right? So somebody has to fill out a form to report, I have this NIL deal. So
Right.
my guess is that's the way the paper flow would work, is they fill out a Google form, or they fill out a document and hand it over and say, here you go, athletics compliance, here's the deals I've got. And either they create a database from that, or they drop them in a folder. But these documents exist somehow, certainly. There is no way universities are just ignoring the NILs that their athletes are getting involved in. And so they asked for those, and same sort of deal. All three claimed FERPA. They said, so Texas, Oklahoma, and Texas A&M all said, nope, you can't have those. That's student private records. And
Do you know if there was litigation?
nobody sued on that. And
Yeah.
again, that's one of the things I would love somebody to file that lawsuit.
Right.
And but even then, you're dealing with, suppose you get a public interest litigator, or somebody from, say, Reporters Committee from Freedom of the Press, or somebody to come and file your lawsuit for you, so your newspaper isn't paying lawyer fees to do this.
Right. Right.
Which is already, it gets pretty expensive on the front end.
Yeah.
You're probably dealing with a good year of litigation, and then a couple years of appeals, to get a good judgment that maybe you'll lose.
Right.
So the motivation to fight that fight over one story for one reporter for a regional newspaper is pretty low. I think, again, I'd love to see that. I'd love to see good law made on that, and get a good victory. I'd hate to see a loss. That's the other deterrent, is that if one person loses, and that's bad law across the whole state. So, but yeah, my sense is that FERPA doesn't extend to this sort of stuff.
Right. It shouldn't. Yeah.
No, definitely shouldn't. I think that if the records got out, probably the state legislature would move quickly to exempt them,
Yeah.
to protect student privacy, right? Or
Yeah,
student athlete privacy.
That's a great point. And I would just note that when this whole NIL debate started, and the NCAA was talking about guardrails, and they were talking transparency. They
Yeah,
wanted
right.
they wanted complete disclosure from the athletes. They wanted to do a documentary strip search on every communication the athlete had with
Yep.
NIL company, or a collective, and that kind of thing. And the movement's been away from that. And now schools are saying you can't have this information, even though this under the state laws that are in place, and then the university policies in states that don't have a state law, they require the athlete to disclose the NIL deals to the institution to
Yep.
make sure that it complies with whatever restrictions there are on NIL deals. So obviously the documents exist.
Yeah.
And now it's all about competitive advantage, disadvantage.
Yes, absolutely.
Do you think that is a motivating factor in these athletics departments, Power 5 athletics departments, saying you're not going to know anything about our NIL activity?
Yeah, I think it is. I think that's again, you're kind of in an arms race here, that the universities are competing with each other for athletes in a battlefield that has not been at least this explicit before.
Right.
You're able to coordinate them, and the sorts of things that's interesting. What they can do is they say, come here, we have our business school has an NIL collective, and there are groups here that will work with you. It's like, we can't officially make this happen, but there are all sorts of organizations that will work with you to make this happen, and look at the opportunities that are here. But knowing full well that the things are going to get reported, but they're gonna keep quiet about them. And it's not just about NIL. We're seeing this happen again, cities, counties, when it comes to trying to recruit businesses. They're competitive as well. They will write into their deals things like, we'll create a special tax district you're not paying taxes for. And also, if any open records requests come to you or to us, we will fight them on your behalf. So that's when the Amazon headquarters were going, and New York was fighting for them, and DC or Northern Virginia was fighting for them, in the DFW area. And some of these deals got leaked. The offers got leaked, and they said things like, yes, if people come asking for records about the deals between the city or the county or the region and Amazon, we're going to deny those records. We'll fight them on your behalf. So it made it very clear where the transparency values were, which is that anything that might get out that would displease the businesses, or in this case, displease the student athletes or their parents or whatever, yeah, we'll fight that for you. And
Yes.
that's very much against a culture of transparency.
Right. All of this. And that really is kind of the big point here, that all these tactics, all these instincts are driven by secrecy, a purposeful attempt to prevent the public from knowing what's going on. And on the backside of this less restrictive NIL market, the NCAA and the Power 5 asking for protective federal legislation that would basically federalize the name, image, and likeness market, among other bad things, in my judgment. And they've painted the sky is falling narrative. We get these stories about these deals, these astronomical deals, but we don't have any way to verify it. And my thinking is, how can you form an intelligent decision from a policy standpoint on the nil market when you don't have any data on it? And I think that goes to the transparency issue.
Yeah, and that's a lot of where the culture of secrecy comes from. It's usually unfounded fears, and that's, I think, the hardest thing. Thinking about transparency and governance, kind of broadly, one of the hardest things to overcome is that resistance, again, of government, of people in power. That when people say, "I want to see what you're up to," then the first response is absolutely not. Like,
No.
you're out
Yeah.
to get me, and this stuff is going to come out, and you're going to use it to embarrass me. Again, some of these studies, and even just talking to people, they'll say, why are you trying to hide your city council meetings so people can't see them? And sometimes
Right.
that hits because I'm afraid I'm going to be embarrassed. Or I'm going to say something, and then people are going to go and make me go viral. So those are the
Right.
so I mean, it's not an irrational fear but it's not. It shouldn't be the thing that overcomes these big goals of being transparent in governance. People should be able to see their city council meeting,
Right.
and if you're a city council representative and you might get a little embarrassed, maybe you shouldn't be a city council representative. There are other
Yeah.
these are public jobs, and so yeah, the culture of transparency really does require people to have a little bit thicker skin and to expect that what they're doing is going to be a public record, or available for public oversight.
How much do you think in higher education, particularly in the Power Five and the schools that are in the big time college sports sweepstakes, how much do you think they're concerned about marketing and branding and reputation and image influences their thinking about secrecy and openness?
Absolutely. I think that we've seen it particularly, certainly in my time in academia, so going on 20 something years now, that the brand is goal one.
Right.
That we have your kind of classic reasons for having a university, right? That why a state would fund it and pour government resources and tax dollars into a university used to be these, it's good for a society. Having a college education is a value in itself. It enriches society and enriches people's lives. And it's also good for business and good for the economy and good for jobs. And that has very much moved away into, college is a very competitive thing. And universities are very competitive for resources
Right.
and for students.
And the students. Yeah.
And as students bear more of the cost of going to a university, so the state funding is decreasing. Probably the number one factor driving all of this is just the absolute decline in state funding for state universities over the last 30, 40 years.
Right.
Is that you've got to make your money somewhere. You've got to stay afloat. These are nonprofits or government agencies run by bureaucrats, run by administrators who got to make the numbers add up, and run by boards who have fiduciary duties to their organizations. And job one is get in students, keep and retain students. And
Yep.
so the model, like how much is put into marketing and communications and admissions to recruit and bring in students, bring in big student bodies, bring in people who will pay tuition to keep the ships running, is the biggest driver I've seen, and not just here at TCU, but everywhere. And it's not just in. We need to have good sports teams, and here at TCU, I think it's a great example that our fortunes as a university, our growth, is largely tied to this university making a very strong commitment to athletics, particularly football, about 25 years ago.
And it paid off.
Around
Yeah.
2003 or 4. And
Yeah.
our growth in the student body, our numbers, our tuition has escalated as well, is very much tied to that. And I had an administrator made it clear to me one time that's like, if the Big 12 didn't come through with a big deal, right, with a big new TV deal when the other universities left, that we might be looking at a $10 or $12 million hit a year from the old contract to the new one. She said, and that money's not going to come from athletics. It's like, we're not going to cut. We're too far deep into athletics to cut it. Well, there's only one other place that there's going to be, and that's the academic side. So the cut
Right.
was going to come from somewhere, and it's made pretty clear it was not going to be athletics. And that's not unique to TCU. That's the way universities
Right.
are these days.
Right.
So I think that is the big driver, that brand, the market communication, not just for athletics, but for the university as a whole. We've got to have the nice rec center with the lazy river, and we've got to have the fancy dorms and the good food, because we are competitive for every single student to come here and pay tuition, because we got to stay afloat. And that's the biggest driver in universities right now.
Yeah, that's such an important point, Professor Stewart. The connection with decrease in state funding and then the need to get money, and that I think that's accelerated the tuition increases. But also the use of big time football and men's basketball and now women's basketball and even some other non-revenue sports, depending on the institution.
Gymnastics, baseball, yeah.
Gymnastics, all that is a marketing and branding tactic. And I think sometimes when we think about college sports, the commentariat tries to compartmentalize the athletic interest from the university interest. There's a clear symbiotic relationship there when it comes to getting butts in the seats and getting the image of and the reputation of your university in a place where you can compete for the best students and keep the classrooms full. And that's become even more true as the exposure of big time college sports has increased. And I think that's something that really has kind of been lost in this discussion. And some of these issues are really higher education issues, not necessarily college sports issues, right?
Yep. And I say that, I agree. And I say this, I love college sports. I was a college journalist covering sports. I played sports in high school. I was friends with a lot of athletes. I've been involved in college sports on the SID side for years and years. I love going to college football games. I love watching the NCAA tournament. I've got lots of friends on the athletic side that I think college sports are a net plus. I'm a big fan, and they add a ton to the student experience and to a community as well. But they shouldn't be the driving factor, right? They shouldn't be driving the bus when it comes to the mission of a university. I've got 2 kids going to colleges, and neither of them particularly care about sports. And one goes to a small private school that does not have big time athletics, and it's fully an academic experience, and she loves it. The other's going to Rice next year, which I'm thrilled about, and they are not good at sports. But by God, they're a marketing man, and so we're going to enjoy that.
Yeah. Well, so this is one more thing I want to talk about, Professor Stewart, and this was the topic of your 2019 article, and that's the increasing use of technology to avoid transparency, like disappearing apps and that kind of thing. You wrote that article in 2019.
Right.
And, one of the things that you talk from the very beginning about, and this is a challenge in a number of different areas, and that is that the law is so slow to change and to adapt to keep up with these new technologies. Can you talk a little bit about that broadly? And then I want to talk just for a little bit about how that is relevant in the college sports space.
Yeah, sure. So kind of related to what we talked about earlier is that when government officials want to get around public information laws, open records laws, there are lots of tools they can do it. And historically, a new technology comes up and public officials think, aha, right? Email is here. We'll just use email instead of having a meeting. Nobody will ever find out. So of course they found out. A few years passed, legislatures passed things saying, okay, emails are also records, right? Digital records are records, emails are records, and if you have a meeting by email, it's a meeting. So they said, aha, but text messages, it's a new thing,
right?
And then the law eventually catches up. So now we know, like, emails are public records, text message are public records. You can't do meetings via text message or chat room or whatever it is. That those all, the laws all got changed and updated, but it took some time. Yeah, the real challenge is the disappearing or vanishing messaging apps, which I call them killer apps, right? They exist to delete the paper trail. That they, by auto deleting messages and by through encryption and other things like that, which can be very, very good for a lot of things. But they also have this side effect, which is that people can hide the trail, including government officials, and they can hide the tracks. And efforts to change these through litigation have failed so far. There's a case in DC, there's a case in Missouri back 2019. Missouri involved the former governor Eric Greitens using, I believe, Confide. He was using Signal or Confide or some combination of them, which they're encrypted end to end, and the messages auto delete, and so there's no record kept. And when a group of attorneys sued saying these guys are deliberately using record destroying software, and the court said, we get that, but there's nothing we can do about it, right? You can't produce a record that doesn't exist, And basically it was like, hey, legislature, if you want to change this, you need to change it, because the law as it exists right now can't handle this. And it, of course, has not been changed at that time in those 4 years. And in DC, similarly, this kind of early in the Trump administration, this was not FOIA, but the Presidential Records Act, that were using a Signal and Confide to leak to journalists largely and to have conversations. They were auto deleting. And of course, the Presidential Records Act requires you retain all of this sort of stuff. And Citizens for Responsibility and Ethics in Washington sued under the Presidential Records Act. The court similarly said, we can't do anything about this, that the law doesn't have an enforcement mechanism. And they specifically said Richard Nixon would have loved this sort of technology, right? Which is not a great endorsement. But nevertheless, it said, our hands are tied. Like, the Presidential Records Act doesn't have a remedy for this. And so really up to legislators or regulators who manage data and document storage to come up with some solutions. And so far, they just really haven't.
Yeah. So, and that has become an issue in college sports. And, I've paid close attention to the work of this transformation committee and some of the recommendations on infractions and enforcement that came from the infractions process committee. In one set of recommendations, they expressed a concern that athletes and their family members and the people that they're associated with were using disappearing app technology to hide unsavory transactions and
Oh, sure, of
communications.
course.
And one of their recommendations is that if the NCAA comes in and says, surrender your electronic devices, the athlete, their family members, their associates, turn over your electronic devices so that we can see everything that's on them to prove whatever the allegation is. And if you don't do that, if you don't turn over those electronic devices, there will be a presumption that you're guilty of whatever it is we think you're guilty of. I think is really troubling. And I wonder, like, how many coaches, how many athletics administrators, how many university presidents are using disappearing app technology? Is anybody
Right.
even asking those questions?
And I'd say that 4 years ago, not that many, but if I were university counsel, I would be telling them to use that, right? That because I just, purely that, if you want to avoid a paper trail and avoid scrutiny,
Right.
Signal or use Confide is going to be encrypted end to end. Somebody's basically have to know your password to get in it and brute force guess it. And they auto delete, so there's no paper trail. Why wouldn't you? Right? That there's no rule against it. There's no. I mean, you'd have to have a moral center, right? I suppose. Which so I wouldn't use it personally for that sort of thing. But otherwise, why wouldn't you? The advantages are all on the side of covering yourself and protecting the people you're communicating with. So even if, for example, the Big Ten presidents did not have a secret third party group chat and forum that they could use, they just could have used something free like Signal to set up a group discussion. It all would have auto deleted and it would have had the same effect.
Right. And that comes back to the very beginning of this discussion. It's been a great discussion. And that is, what's the purpose of these laws?
Yeah.
And what impact does the climate and culture of non-transparency have on our relationship to our institutions in the long run? And, where are we headed with this? And how do you see this, on the scale of cynicism to optimism,
Right.
and how it impacts not, American values, but in the athletics context, the rights and interests of athletes?
Yeah. Yeah. I think it's sometimes hard to get people to care. So
Right.
I think that's the first thing is that if you're in the FOIA or transparency advocacy community, we care deeply about these sorts of things. And when a bad bill comes up, we try to get it killed. We work with our advocacy groups to push better legislation. So I mean, there are these sorts of things happening, from the advocacy groups to try to make things better. And we get incrementally better at times. So it's not like it's hopeless. There are things you can actually do to talk to your state representative, your U.S. representative, and to try to get some of these changes made. It may be an uphill battle, but changes do made bad court decisions get overturned by legislation. I mean, there's ways to make the ball inch forward, but changing culture is a lot harder, and that's that where people care more about as a value government transparency and accountability, and as a value athletic department accountability and transparency more than they care about their team winning and getting the best athletes. And the incentives are not lined up on the side of transparency right there. So I'd be a little more cynical about that. And ultimately we'll come to, sadly, what draws attention to these is when there's a really bad scandal. So something horrible happens, it's a Baylor, it's a Louisville, and you look at like a New Mexico State, the sort of things that are happening right now. You're like, how did things get here? And the only way you find out is through dogged open records work. Michigan State and then the gymnastics scandal and that sort of stuff. Like those were uncovered by investigative reporters using open records laws. And so if you see those values, like how can we avoid this again? Good transparency and people realize that what they're doing is going to be seen and maybe they don't do those bad things. So I mean, yes, it can happen, but I think that the advocacy comes more from people seeing the bad things that happen and maybe how can we prevent that?
Right. Well, if there was ever a time for more transparency, it is now.
Yep,
On
I'm with you.
multiple levels. Yeah.
Well, the best
So
time was yesterday, and the next best time is now, right? So,
yeah,
right. The best
yeah.
time was 10 years ago. Yeah, the next best time is now.
So, Professor Stewart, I want to thank you so much for joining. This has been a great discussion, and want to leave the door open to talking to you again. And if your class needs some suggestions on public records assignments, I have some thoughts.
Fantastic. We are actually looking for one this semester. So
that I could share. I'll share with
glad
you
to entertain
privately.
Terrific. Yeah, and I really enjoyed talking to you. Good luck with your podcast here.
Yeah. Thanks so much. Take care.